Welcome to Looking at Legal Stuff. Today we have a motion for adequate cause with a couple where mom is motioning the court to appoint a GAL, and she asks that the court give her sole decision-making power until the GAL can investigate her claims that the children's stepmother is interfering in parental decisions. She also wants the stepmom to be supervised around the children until the GAL has finished her investigation. Mom claims that Dad is allowing the stepmother to interject herself into medical decisions, and she's even decided to change their primary care doctor behind Mom's back and without her permission. She says she also makes and cancels other medical appointments without even consulting Mom. Mom also claims that the stepmother has an unhealthy obsession over the children's diet and cholesterol readings, and that she's giving the children the wrong ideas about food and healthy eating, causing them to act out at school. Dad's lawyer says this case is made up of nothing more than Mom's petty sniping, and that the stepmom had no idea that Mom felt this way because she has a boatload of text messages from her that say exactly the opposite. What does the judge think of this motion? Let's find out.
What happened there? Okay, so on the McMahon, or I think I'm saying that right, Ashley McMahon and Bryce McMahon.
Yes, Your Honor.
Okay. This is on for adequate cause hearing today.
I'm sorry, Your Honor, what was that?
This is on for adequate cause hearing today.
Yes, Your Honor.
Okay, go ahead.
Yes, Your Honor, this is a little bit of a convoluted case and there's quite a few pleadings. Has the court had a chance to review all the pleadings that have been filed as there is so voluminous?
I did. I received the bench copies that were provided to Judge Hahn, and I did review everything in the file. So I've reviewed everything that's been filed at least.
Okay, thank you. We're not going to be responding to everything in the pleadings as that would probably take the remainder of the day until 5 o'clock. So I'm going to go through the reasons why we contend that there is adequate cause. What we have here is a totality of the circumstances. There's not any one particular thing giving rise to adequate cause here. It's quite a combination of a few things. The allegations that are made by my client are supported by clear and convincing evidence as evidenced by the voluminous filings in this case. The first thing is that there was a parenting plan entered in December of 2019. There's been no modification since that time. Parties have tried their hardest to work together to come to agreements and to follow it, and over 5 years, that has just fallen apart. It's pretty obvious from the pleadings, again, that mother and stepmother in this case have kept copious records, going back and forth, texting paragraphs between themselves, which gives it's pretty obvious that they knew something was going to happen and they were keeping very accurate records just in case that something like today would happen where they needed to be in court to modify the parenting plan. We're dealing with a situation where stepmother is inserting herself into the parenting plan and into being a de facto parent when she is not. She is a stepmom. She is overstepping her bounds as a step parent. Some of the examples are when stepmom unilaterally changed the primary care provider for the children. The children had been seeing the same primary care provider their entire lives. That was January of this year. Stepmom went and changed the primary care provider without notice or consent of my client. She then validated her choice to do so by saying, oh, my aunt knows this person. I really like them. I didn't like the girl's primary care provider, so I changed it. Then in April of 2024, a CPS investigation was initiated due to concerns about the twin girls concerning behaviors towards food. That has to do with the girls hoarding snacks at school, the girls stating that food is a punishment and a consequence. The school was the one who was so concerned that it reported these concerning behaviors. While the CPS report was unfounded, the CPS report that we filed under seal evidences that the girls themselves are stating things that are concerning. Again, that gives rise to adequate cause because both parties' pleadings in this case are peppered with child hearsay statements. The only way for a court to really know what's going on for these statements is to appoint a GAL to investigate what the girls themselves are saying and are being alleged in both parties' pleadings. By granting a motion and an order for a GAL is adequate cause in and of itself to modify a parenting plan. Now, in text messages, dad will say things like, thank you for bringing up your concerns, but if you have any issues, please address your concerns with stepmom. That is inappropriate because the issues that are being concerned and being talked about between the parents should be discussed between mom and dad, not mom and stepmom. And while I understand the argument is that stepmom acts as a mouthpiece and then as a point person for father's home, the real issue is that stepmom is the one making these decisions and father is endorsing them. It's pretty clear from the voluminous text that stepmom is the one who's been responsible for medical decisions and medical care within father's home. Why does stepmom have to be involved in scheduling of things when she is allowed to attend therapy sessions? Instead, father goes and cancels entire therapy appointments because stepmom couldn't be involved in the scheduling. Why does mom need to be involved in the scheduling when it's very clear from the text communications that she's allowed to be there? Stepmom is, for some reason, obsessed with the girls' cholesterol readings. Dad is not the one who's obsessed by that. Stepmom is. Stepmom messaged mom, like, what are we going to do about these cholesterol readings? Well, the primary care provider said, there's not a problem here. It's a reading that is 3 points higher. I'm not concerned about it. I don't want to do anything. Then stepmom interjects herself, well, we need to do something about this, which again is coming from stepmom, not father. The catalyst here, because other side contends that this has been going on for 5 years. It's clear that stepmom and mom have gotten along great. There's a lot of documentation and evidence saying they've been getting along great. What's really happened here is these two sides have not really gotten along. It just appears that they have on paper, but there's always been some simmering issues underneath the surface. These really came to a head after a CPS initiated an investigation. Father and stepmom blamed mom for initiating it when really it was the school that did it. When mom talked with CPS said, hey, you should be talking to dad about these issues. Never occurred to my client that she could just talk to father, so that's what she did. Mom went and split the middle ground here and said, I'm just going to create a group chat so that I can talk to dad and stepmom, put everybody in a room together in the group chat so that we can work through these issues together. Then the straw that broke that camel's back was when mom was trying to talk with both stepmom and dad about going to a school event. And stepmom said, you can't do that. He's going, you can't come. That's not what you should be doing. When it's very clear that the parenting plan in section 14 says that both parents are allowed and are encouraged to attend the events and that neither parent shall be excluded for an event. Here you have stepmom interjecting herself into the conversation saying, nope, you're not allowed to do that, mom, which again, she's overstepping her bounds. Then after we filed our initial pleadings and after the responsive pleadings were filed, we had to put in our reply declaration that mom is still trying to have conversations with dad. Looks like dad is screenshotting things, sending it to stepmom. Stepmom then is saying into the group chat that mom is no longer a part of, hey, you could have just put this here, it'd have been a lot easier. My client's not trying to be petty. She's just trying to watch out for the care of her daughters. She's trying to do what is best for them. She really thought about modifying the parenting plan back in January when the primary care provider was switched without permission, consent, or notice. Then the CPS investigation was initiated in April. And so it's a culmination of these events that really gives rise to adequate cause here. This is very concerning that stepmom keeps overstepping her bounds. To address a few of the allegations in the responsive pleadings, the only time that mom ever scheduled anything on dad's parenting time was after the CPS worker said that the girls need to get into therapy. So mom did that ASAP. And then stepmom and dad come back and say, oh, you did it on our time. We're not okay with that. That's the only time that's ever happened, and it was done out of an abundance of caution for the girls because that was a CPS recommendation. Mom doesn't rely on stepmom for making decisions. What she does is she informs stepmom because stepmom is a part of dad's household. There's no reliance. There is a relay of information to stepmom as per what is said in the parenting plan. When it came to the allegation that mom is not including dad in paperwork, that only happened one time, and it was with Randall's Children's Hospital when one of the girls was transferred from St. John's. St. John's had the medical information, including dad's contact information. When the daughter was transferred to Randall's, for some reason, his information was not included, but mom did include him in the paperwork and in documents for St. John's Hospital. What we're asking for here is a little unorthodox. I don't know what the right solution is because mom or stepmom is so ingratiated in what's going on here. We would say that we don't want her involved in any decision making. We don't want the girls around her at all while this is going on due to the allegations that the girls have made within the CPS report and all the hearsay that's been going on. So what we propose is that a GAL be appointed to investigate what the girls are saying that is substantiated in both the pleadings here. And that while this investigation goes on, mom has sole decision making until a GAL recommendation and report can be finished and filed with the court. And then at that point in time, the parties should be able to come up with a parenting plan based on the GAL recommendations. It's very clear that something's going on here. The girls are, CPS got involved. Stepmom is switching primary care providers. Stepmom and dad are saying that these two parties have historically gotten along and everything's fine, when really that might be what it looks like on paper. But for the last year, at least since January, this has just been an issue waiting to happen. And now it's come to a head. These little girls are in the middle. From the CPS investigation and from all the pleadings, they have a lot to say. Someone needs to hear what they have to say. That should be a GAL, and that's going to give rise to adequate cause right there. So we would ask that a GAL be appointed, and that in the interim between now and when a GAL report can be filed with the court, that mom have sole decision making.
All right, counsel.
Yeah, and good afternoon, Your Honor. So my client is asking that the court not find there's no adequate cause to modify the parenting plan. Cases like this are exactly why there is the initial burden, in my opinion, of adequate cause before modifying. So the parties can harass each other and try and change the parenting plan whenever they feel like. Mother's motion is based on petty sniping and unsupported conclusions, which is not a basis for adequate cause. My client and his wife, Kayla, are good, loving parents, and they always have the daughter's best interest at heart. Further, until recently, mother has behaved as if this is true and as if Kayla is a second mother to the girls. In fact, she's called her a second mother to the girls. What mother is requesting is not a little change. My client would not be able to keep his job if the request was granted, and his wife's time with the kids would have to be monitored. And she's essentially trying to exclude Kayla, his wife, who she previously called the girl's mom, from the family life and from the girl's life, which is not appropriate. In order to modify the parenting plan based on mother's request, the court would have to find adequate cause for a major modification, because right now they're joint custodians, and a shared parenting plan is not possible based on what she's proposing, that Kayla's time be supervised. And so in order to do that, the court would have to find there's detrimental circumstances. Instead, it would be detrimental for them to modify the parenting plan. Mother indicates via her counsel that this is based on a totality of the circumstances. And that's because there's nothing she can point to that would be a basis to modify the parenting plan alone. So, going through these things that she indicates are the totality, is that based on my clients ordering the allegedly wrong colored cleats? Is that based on my clients telling the girls to wear masks during the pandemic? She indicates that there are both my client's wife and my client knew there was going to be an issue, so they kept copious records of text messages. clients just don't delete their text messages. I don't personally delete my text messages. That's not keeping record to be prepared to go to court at any time. That's just keeping your text messages. I also want to point out the lack of consistency with mother's position. She has requested Kayla, StepMother's help continuously, and she's praised her for that help. It seems in the last few months, she's changed her mind and expects that my client and his wife automatically understand that she's changing her mind and conform. But instead, she's using this involvement of Kayla that she herself has cultivated into requesting a major modification of the parenting plan. So I know the court has reviewed the text messages submitted. I just want to highlight a few of mother's comments to my client. She says there's an underlying current that they don't like each other. This is news to my client and his wife. And it is an interesting statement that my client was supposed to expect that text messages saying nice complimentary things were actually an attempt to cover up her disdain as she indicates in her pleadings. So October 2022, she thanks Kayla for making it work out and refers to her as one of the girls' moms. April 2023, she asked Kayla what her routine is at home so she can have the girls follow it. May 2023, she says the girls and we are all lucky to have you in reference to Kayla. June 2023, Kayla and Mother do yard work together. June 2023, Mother says she appreciates Kayla. September 2023, Mother says the girls and I are lucky that Bryce, my client, chose you. September 2023, she says, I trust you 100% with everything. October 2023, she says she would be 1,000% comfortable with my client's wife, Kayla, setting up counseling without her being present. She indicates both in her pleadings and through argument that she's the one that created the group chat to include my client's wife. How is my client's wife supposed to know that she no longer wants her to be involved when she's creating a group chat to include her and sending communications like, I 1,000% feel comfortable with you scheduling doctor's appointments without me being present or apparently being involved. Regarding the food issues, this has been addressed, and the pleadings, I only want to touch on it. The real issues, my client hasn't changed what he feeds the daughters. Either way, I hardly think, putting spinach and sandwich wraps that the girls love, clearly, and making healthier foods is a reason to modify the parenting plan. But as indicated in the pleadings, there's a good balance. There's healthy food, there's pizza on certain nights, there's dessert. It's a well-rounded food groups. In fact, it's Mother, again, back to the inconsistency, it's Mother who has decided she is giving up sugar and gluten. This is indicated in the CPS notes where she indicates sugar is poison. When this occurred, and it's also indicated in the emails between the teacher and my client, when this occurred, this is when the girls started having issues with sneaking snacks and wanting the school foods. So that really is the issue here. The girls' food counselor, who both parties agreed to, not because the girls were having problems, but because they thought it would be a good resource. The girls' food counselor was surprised to learn a CPS investigation was initiated because there really is nothing going on here. Again, it's, this totality of the circumstances, but really it's just these petty arguments being thrown back and forth with nothing to support them. Mother seems to she's moved off the food thing. It seems like she's really hanging her hat on this primary care doctor issue. Well, that's not a basis to modify the parenting plan. That's a motion for contempt if it was true. And it's not true. My client's wife did schedule a doctor's visit for the girls' annual with a doctor they had previously seen and liked. She did not change their primary care doctor. So if that occurred or there was miscommunication there, that could have been addressed between the parties, could have been addressed in a motion for contempt. That is not a basis to modify the parenting plan. And again, that is not what occurred. Regarding the field trip, if you look at the parenting plan, it indicates the children should be accompanied by the parent they are residing with to the field trip. And that is something that was left out in counsel's argument. That is a very important part. My clients were under the impression that only one parent could go with the child to the field trip. Counseling, she indicates that my client has a history of canceling appointments. I believe she's referring just to this counseling appointment. And so the idea that this is something ongoing or there's a history is misleading. So this counseling appointment was scheduled without getting confirmation on the counselor, and it was scheduled during my client's parenting time without first asking. And my client also wanted to schedule a counseling appointment with the client, and had proposed a counselor, but the parties agreed that they didn't want to go with that counselor. So that the fact that the mother unilaterally found one, scheduled it during father's parenting time without letting him know, that's a violation of the parenting plan. And the fact that he canceled an appointment that was a violation of the parenting plan, both of the decision-making provision and just the fact that it was scheduled during his parenting time is again, not a basis to modify the parenting plan. I mean, mother's essentially saying, yeah, I see that there's not enough to modify the parenting plan. So I'm hoping that the court will appoint a guardian ad litem to investigate and find a problem. That's not why we have a guardian ad litem. That's not the purpose of finding adequate cost to open the parenting plan and try to find a problem. There is no problem here. And mother's requests aren't in the best interest for the girls. What is in the best interest for the girls is to continue with the current parenting plan. The parties both agree the girls are healthy and thriving. If the court finds adequate cause, there should be no changes to the parenting plan. Decision-making should continue to be joint. Mother is the one who has made unilateral changes with counseling. There's no indication that my client isn't able to make medical decisions or school decisions. And it seems historically the parties have actually worked very well together. And there's no indication that one parent, specifically my client, is making decisions that aren't in the best interests of the children. So again, we ask the court deny adequate cause, award my client attorney's fees. There's just no basis for it here.
Counsel response?
Yes, Your Honor. For all the text messages where my client is praising Kayla, stepmom, in this situation, October 2022 through October of 2023 are what are mentioned. The real issues started arising in January of 2024 with the change of the primary care provider. In the text messages that stepmom sent to mom, it was, oh, well, he can stay the primary care provider. Stepmom is dictating to mother what can and cannot happen. Now, while that would have been appropriate to file for contempt, my client didn't, because she didn't want to modify anything at that time. She didn't find it necessary. She didn't want to make waves. Then in 2024, in April, CPS initiated an investigation. CPS in the report says that, well, there is withholding of food as a form of discipline. This is problematic. Yes, the girls are relatively happy and healthy right now, but if using food as a consequence, as the girls state, and using food as discipline is continued, the girls are not going to be happy and healthy, either mentally or physically. The concerning issues were brought up by teachers on dad's time, not mom's time. Again, these are issues that the girls are having during father's time. When it comes to adequate cause, we are not asking for the girls to be put in contact with the GAL so that the GAL can go on a fishing expedition and adequate cause can be found. There is adequate cause based on the clear and convincing evidence that is put forward in the pleadings. This is not petty sniping. Petty sniping would be screenshotting a conversation from another party, putting it into a group chat, and one party saying, you could have just put this in the group chat instead of sending it to someone directly. That's petty. That's not what my client did here. Again, these allegations are supported by clear and convincing evidence. The totality of the circumstances here, I keep using that because it's not just one thing giving rise to adequate cause. It is multiple things. It is a change in a primary care provider with no notice or consent. It is stepmom dictating what can and cannot be done under the parenting plan. It is father deferring to stepmom for decision making. It's not just stepmom being a mouthpiece for the family. It is her literally making decisions for the girls while they are in father's home. This is concerning. Both pleadings, again, full of child hearsay from the girls that should be investigated further, but on the face, there is adequate cause to modify the parenting plan. This is not necessarily a major modification, and it is not a minor modification. We don't know what the modification is in the long run, but in the short term, it is a minor modification because in the short term, mom is asking for sole decision making during the pendency of a GAL investigation. That investigation may yield results that would change the parenting plan for a minor modification or a major. We do not know yet based on what the GAL, if appointed, is going to recommend. Again, this is a situation that has been a long time coming. These aren't just friendly text messages between the parties. It is an as per my last text message. It is copious amounts of documentation to use at a later time, which both parties have done so. We would still ask that the court find adequate cause, that a GAL be appointed, mom be made sole decision maker during the interim process, and we're also asking for fees to bring this motion.
Okay, I guess there's one question I have that the CPS investigation, that ended up as being, from what I can see, that was an unfounded finding. Is that right?
That's correct, Your Honor, and there were no safety concerns.
That is correct. As far as no safety concerns, I would agree, but CPS did recommend counseling for the girls. And when my client tried to schedule counseling, that was shut down because
I can read the letter, counsel. It was an unfounded investigation. That was my question, correct?
Correct.
Okay. So I guess this is one of those cases, this is a case where there's it's a 50-50 plan. Each party, they're essentially both custodians. If they have disagreements, there's a paragraph 6 in the parenting plan that allows them to come back to court and have the court help them solve decision-making issues, which was not utilized. I don't see this as a case. And again, I reviewed that. I'm going to deny adequate cause.
And we're requesting attorney's fees.
Counsel, any comment on that?
As per section 6 that you just addressed, the appropriate venue for this is to come to court. My client came to court after a culmination of issues happened to address all of the issues simultaneously with an adequate cause motion. Therefore, the parenting plan was followed. Therefore, fees are not appropriate.
And Your Honor, there was no attempt to settle or discuss these issues. It was just, we're going to file to modify the parenting plan because we don't agree on this one issue. So again, my clients have spent a considerable amount of attorney's fees, experienced a considerable amount of stress. I'm asking that he be awarded attorney's fees.
All right. I'm just one second here. All right, I'm looking back at the Southport worksheets just purely on financial basis, because that would be the basis under which the court would order fees, if any. I'm not inclined to order fees based on that. So I do have a proposed order that
Okay.
counsel, you should have both, I think this was filed, I'm not sure when this came in, but it was part of the packet that I received. So with the exception of, I'm going to cross out section 7 of that order. I'm going to sign that order.
Okay, great. Thank you, Your Honor.
Welcome. We'll sign that order.
Okay, thank you, counsel.
Thank you.